Welcome all in the fifth lecture of the series subject Law for Engineers, and the today's topic is judicial activism. In previous videos, we have covered like fundamental rights, fundamental duties, directive principles, and many more things. In today's lecture, we will learn about judicial activism. What is judicial activism? What are the methods? And how can we go through with the contents? What are the roles in our daily life? We will learn this. So let's start our today's session. First of all, we will discuss about the concept of judicial activism. Before moving ahead, I want to clear that the judicial activism is a type of method or a provision when any time if a higher court pass a contradictory verdict or any convention which against to the constitution. So in such cases the court has the power to review its own decision or any other rules. Judicial activism is also associated with this kind of situation when two contradictory concepts collision with each other, as court says the or court pass the different verdict, and the constitution against that verdict. In these situations, the court can review its own decision or may change or can use some different rules. So let's start our topic, the concept of judicial activism. The judicial activism originated in United States in 1947. It has been seen in India since the emergency days. According to the Black Laws Dictionary, judicial activism as a philosophy of judicial decision making, whereby judges allows their personal views about public policy, among other factors, to guide their decisions. It means what happening towards our lives, judges can take them in consideration and follow their verdicts. Judicial activism is the judicial philosophy. The court can and should go beyond the words of the constitution or a statute to consider broader societal implications of its decisions. It is sometimes used as an antonym of judicial restraints. It means what is written in the constitution and what are the rules, what are the binding rules to the courts. The court can go beyond that to according to the situation, and according to the time. These all concepts come in under judicial activism. Now we will learn about some judicial activism methods. What are the methods by which we can calculate the effect of judicial activism and by which this judicial activism take place? The first one is judicial review. Judicial review, it means as a court, as I have discussed earlier, if a court passes any verdict or declare any judiciary interpretation, so it can take that judicial verdict for review as its own review also, and can change the laws, change the verdict. It is the power of judiciary to interpret the constitution and to declare any such law or order of the legislature and executive void if it finds them in conflict with the constitution. This is the most common thing that everyone know about this. PIL, public interest litigation. Anyone India, anyone Indian citizen can file public interest litigation PIL in the court about any current issue which affecting the human lives or the citizen lives in India. But there is a condition: the petition is accepted by the court only if there is an interest of large public involved. And the aggrieved party means which parties or which person is going to the court does not file the petition. Okay. Or the person cannot go to the court. The next method is constitutional interpretation. It's the interpretation of constitutional laws, articles, etc. The next one is access of international statute for ensuring constitutional rights. It means any court can taken into consideration the foreign courts decisions or laws, etc. The next one is supervisory power of the higher court on the lower courts. As a lower court pass any verdict that is contradictory or against to the constitution, then the higher court can take it into the review and can become it void. Now, the significance of judicial activism. It is an effective tool for upholding citizens' rights and implementing constitutional principles when the executive and legislature fails to do so. As like PIL, anyone can file PIL in the public interest and court can listen that matter. Next one, citizen have the judiciary as the last hope. As we all know, if anyone is not listening to you, anyone is not listening to the voice of the society, not listening to the voice of the citizens, then what will the citizen do? The citizens can go to the court or the higher court to protect their rights when all the doors are closed. As it's said also that Indian judiciary has been considered as the guardian and protector of the Indian constitution. The next, there are provisions in the constitution itself for the judiciary to adopt a proactive role. Article 13 with the Article 32 and the Article 2 to 6 of the Constitution provides the power of judicial review to the higher judiciary to declare any executive, legislative, or administrative action void. What means it can remove that particular verdict that is contradictory or can stop that particular law. According to the experts, the shift from locus stance to public interest litigation made the judicial process more participatory and democratic. As anyone with the public interest can go to the court and court will listen to you and pass any law or any verdict according to the situation. This is said that judicial activism counters the opinion that the judiciary is a mere spectator. That anyone says, yo, or in any country regions, we will say that judiciary is just a spectator, or is like a judiciary is like a spectators, or like a audience also. So it's not like that. It can take the serious matters into account and can pass the laws, or also can close the laws which are against to the society, or by which the society can be harmed. Judicial activism can mostly seen under the cases related to equality and social justice, life and personal liberty, secularism and religious freedom. These are the hot topics in which the judicial activism can take place. So this is all in this lecture. Prepare your notes and read it carefully.